Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I want to talk about what happens if your business or you personally are under audit by the Internal Revenue Service and you can't come to a resolution about the audit with the revenue agent who's handling the audit for the IRS. In other words, you get to the end of the audit and you can't come to an agreement on how much is owed or if anything is owed, and there's just no resolution. What happens next? What do you do? In general terms, what happens at the end of an audit when the revenue agent writes up their report, if there's not an agreed resolution, if the taxpayer does not agree with the resolution proposed by the revenue agent, the Internal Revenue Service, the IRS, will send the taxpayer what is often called a 30-day letter. Essentially what that is a letter to the taxpayer that says we have this unresolved issue. You can take this issue administratively to the appeals office of the IRS, but you need to do so and file a protest within 30 days. And so that's why it's called a 30-day letter. So what happens then if you get a 30-day letter is if you want to appeal to the IRS appeals office, you have to file a protest. Now there are some exceptions to that rule. Like with most things, there are exceptions. If the amount at issue is less than $25,000, you can simply appeal the dispute to the appeals office without filing a formal protest. But typically and always with matters over $25,000 in issue, you're going to want to file a written protest. You probably are going to want to file a written protest anyway because it's a good opportunity to set forth your position to the IRS appeals officer. So who is the appeals officer? The appeals officer is an IRS employee who is different from the revenue agent who handled your audit. The appeals office was set up as a way to have administrative appeals at the agency level, at the IRS level, before cases would go to court. And the mission of the appeals office is to resolve cases. Typically, the way that appeals officers look at cases is they are looking at the case to see if they can't resolve it fairly, impartially to both parties, and they look at what they call hazards of litigation. In other words, if this case were to go to court, what are the dangers and risks that the IRS might lose or might not get as much as they're asking? And so the appeals officer is supposed to be an independent person who would take a fresh look at your audit case and make a determination what's fair and what's reasonable, how can this matter be resolved short of litigation, and what are the hazards of litigation. The appeals office typically resolves about 80 to 90% of cases that come before it. So for most tax cases that are not resolved at the audit level with the revenue agent, I would say that the overwhelming majority are resolved at the appeals office. And so it's a great opportunity, if you don't agree with the revenue agent, to try to get your case resolved without the time and expense of going to court. What you have to do is, I said, you have to file your protest within essentially a 30-day period. The 30-day letter will set forth what your deadline is for filing your protest, and so you will have that period of time to get your protest prepared and filed with the IRS to get the ball rolling for your appeal to be heard by the appeals office. Now, there are a certain number of specific things that have to go into a written protest. And Publication 5, which you will get a copy of with your 30-day letter, sets forth what those requirements are. The main things that go into the meat of the protest, the main things that are the meat of the protest, are setting forth what the facts are and what the law is, and of course what your conclusions are based on the facts and the law. Now, obviously, you can prepare your own protest. If you are a taxpayer, you can have your whoever handled your audit prepare your protest if it's your CPA or an enrolled agent or your attorney. But at this point, what you're doing on your protest is making essentially a legal argument. It's almost like a legal brief based on case law, and that law being, or statutory law, and that law being applied to the facts of your case. And so in this respect, even though you can have your authorized representative who may not be an attorney who handled your audit prepare the protest for you, it might be advisable to at least consider having an attorney who is typically going to be more comfortable not only with legal research but also making arguments based on the law and the facts. It may be more prudent for you to consider having an attorney prepare your written protest and handle that protest and that appeal for you at the appeals office. So, because what happens after you file your protest is you will hear eventually from, or your authorized representative will hear from, the appeals officer to whom the case has been assigned. And at some point, an appeals conference will be scheduled. It typically is done by telephone with the appeals officer, although it's not uncommon, and it's often the way to go to request a face-to-face hearing before the appeals office and to have your case heard at a local office so that you or your representative can go in and meet face-to-face with the appeals officer. It's always preferable, in my opinion, to have a face-to-face conference with the appeals officer. The appeals officer will hear your arguments, will look at your protest, may ask for more information, and at that point, there's going to be a possible resolution of your case based on the facts, the law, the hazards of litigation, all those things that would go into the appeals officer's determination of what would be a fair and reasonable way to settle this case short of going to litigation. If for some reason you cannot settle your case at the appeals office, and there are, I guess, a small number of cases that go through audits, go through appeals, still not resolved, then at that point you are looking at going to court. That's beyond the scope of the video for today, but typically what happens at the point that there is no resolution at the appeals office is the Internal Revenue Service will, if it's a deficiency case where the IRS is saying you owe money because you didn't pay a sufficient amount of taxes, that type of thing. If you can't get it resolved at the appeals office, typically what happens is the IRS will send you what is then called a 90-day letter or a statutory notice. The 90-day letter gives you 90 days, and the deadline is set forth in the letter itself. It gives you that period of time within which to file a petition with the U.S. Tax Court. Now, at the appeals level, if you get a 30-day letter, you're talking about just going from the audit level, the revenue agent, to still within the IRS at the administrative level at the appeals office. And if you need more time than the 30 days to prepare your protest, appeals officers may be willing to, not the appeals officer, the revenue agent may be willing to work with you to give you more time to prepare your protest. You'd have to get that, you'd have to make that request. You'd have to get approval and consent to have more time to do the 30-day to get the protest in if you can't make it within the 30 days. But you at least have that opportunity, if you need more time, to talk to the revenue agent about doing that. With the 90-day letter, once you get that from the IRS, that's based on federal statute, federal law. there is a hard 90-day deadline, and your letter, if you get a 90-day letter or statutory notice or a notice of deficiency, those are all synonymous terms. If you get that, you have to file your petition with the tax court within the deadline period, within the 90-day period that's set forth in your letter. If you miss it, you've missed it. There's no ifs, ands, or buts about that. So anyway, in short and in conclusion, I would say that if you're under audit by the IRS and you can't resolve it at the level with the revenue agent, don't fret too much, because you have another bite at the apple with the IRS at the appeals office, and you should definitely consider taking advantage of that opportunity by getting a 30-day letter from the IRS and filing your written protest within that 30-day period and going to appeals, because more likely than not, you'll be able to work out a reasonable resolution of your case at the appeals office. But you want to make sure that your protest is well done, addresses all the relevant facts, addresses all the law that's applicable, is persuasive about applying the facts to the law, and putting your best foot forward with the appeals officer. If you do that and you present a good case at your appeals conference with the appeals officer, there's a good chance, a strong chance, that you're going to be able to work out your tax case at the appeals level without having to go to court. All right, that's it for today. I hope that helps, and we'll talk to you next time.